Good morning, everyone. Thank you for joining us for this 6th edition of the AI Pact webinars. The AI Pact is an initiative launched by the European Commission in May 2024 to directly engage with stakeholders and support them in the implementation of the AI Act. Our time together is a unique opportunity to discuss the AI Act. I am Marion Dac, I'm law professor at Artois University, and I will be moderating this webinar today. Our session today will focus on the specific topic of general purpose AI models, GPAI models, under the AI Act and the GPAI package. To discuss, we have already 3 guest speakers directly from DG Connect. I'm very happy to introduce them. We will have Jordanka Ivanova, she's Head of Sector, Legal Oversight of the AI Act implementation at the AI Office. We will have Sabrina Kuspert, she's Policy Officer for General Purpose AI Coordination, also at the AI Office. And finally, we have Lauro Langosco, he's Technology Expert at the AI Office. Welcome. Thank you for being with us today. Our session today will be divided into 3 main parts. First, we will discuss the recently published Code of Practice for GPAI models. Then we will exchange on the guidelines, the European Commission guidelines on the scope of obligation for providers of GPAI models. And finally, we will exchange on the notice explanatory and template for the public summary of training content for GPAI models. We aim to make this webinar interactive. Therefore, we are using the Slido application and we will take a question from the audience. We will do that after each of the 3 parts of the webinar, and you can find the QR code to directly connect with the Slido application on your screen. So, before exploring our first topic, it's certainly useful to have a little recap and to map the GPAI package. So the AI Act set up specific rules for GPAI, and before exploring these rules on details, Sabrina, can you first explain why the EU legislators has actually decided to adopt rules on GPAI models?
Thank you, Marion. So AI promises huge benefits to our economy and the society, and general purpose AI models play an important role in this regard. In one sentence, why the rules matter is because they ensure that advanced AI models in Europe are not only innovative, but also safe and transparent. But let's deep dive on this. Let me first start with the crucial role of general purpose AI models, and then coming to the rationale of the rules. General purpose AI models can be used for a variety of tasks, so they already form the basis for many downstream applications across the European Union. For example, businesses and other developers integrate them in the banking sector, in education, or in scientific research. So you see that general purpose AI models play an important role. And the AI Act aims to ensure that anyone who wants to build on these models actually has all the information they need to do so safe and responsibly. And it also supports better enforcement of copyright protection. However, let's not forget that some of these general purpose AI models could pose systemic risks. They could lower the bar for weapon development and chemical or biological weapons, or they could create issues related to loss of control over the model. And so a part of the general purpose AI rules also aims to ensure that these systemic risks are assessed and mitigated. So all in all, these rules aim to ensure that Europeans can trust what AI has to offer.
Thank you very much, Sabrina. So the provision on GPAI models are regulated under the AI Act, so that's Chapter 5. Jordanka, what are the main obligations for GPAI models under the AI Act?
Yes, indeed. There are specific obligations for all providers who place those models on the European market. So as explained by Sabrina, first for all these general purpose AI models that can be integrated into a variety of applications downstream, we aim to ensure this transparency across the value chain. So that's why the AI Act envisaged specific information that these model providers should document about the models, and these are very detailed and prescribed in 2 annexes of the AI Act regarding the design of the model, the training data, other elements that are very clearly listed, and that with this documentation, they should be provided to the AI office, which is responsible for the future supervision of these models, or also to national competent authorities that would be responsible for downstream applications built on these models under the AI Act. And then there are also some transparency information that should be provided and documented also and given to the downstream providers that is clearly listed in Annex 12 of the AI Act. And then these downstream providers can also request other information when this is necessary for them to properly understand the limitations, capabilities of these models and to fulfill their obligations also under the AI Act. Then there are also additional obligations that are related more to the copyright compliance, which rather aim to facilitate rather than otherwise prejudice or affect. So these are obligations for those providers to have a policy at place to ensure this compliance with copyright legislation, and here we have relevant directives, in particular the Digital Single Market Directive, relevant exceptions there that could be relied upon from text and data mining, in particular also to rely and use data for the training of these models when, if in case right holders have reserved their rights. Then model providers should duly respect also these reservations. And the objective with this policy is to ensure also that providers can take effective measures to comply with their existing obligations. And then there is also another obligation for the providers to provide public transparency also to everyone for the type of data they have used for the training of the general purpose AI models. And this can be relevant for right holders, but also broader public transparency and other parties. For these broader obligations, it's very important that there is a tailored exception for open source models released under free and open source licenses when they are provided and ensure sufficient transparency, which aims to actually promote the uptake and innovation of these models under specific conditions that we are also going to further talk about later when we discuss the guidelines. We have clarified them there. And importantly, they only apply for these transparency obligations for the documentation towards the office and downstream providers, but not from the copyright and the summary. And they also are not applicable in case the model poses systemic risks because of exactly the risks and the importance also to provide that information then. Secondly, we have also this proportionate approach in the AI Act that obviously, I said before, when we have significant risks for some of the really frontier, most powerful models, the AI Act envisage additional obligations for those providers who should ensure that they perform model evaluations in accordance with state-of-the-art technologies, including red teaming. They assess, mitigate these systemic risks that could really affect widely the European Union market, but also safety, security, fundamental rights more broadly, and providers implement appropriate measures for that. And then there are also obligations related to the reporting of serious incidents and also for taking measures to ensure effective cybersecurity and protection also of the architecture and the infrastructure. So all these are a package of very important rules that have already become applicable as of 2nd of August this year. And we are going later to discuss the importance of, for all providers who place models on the market after the date to ensure full compliance with the rules. We have also specific grandfathering for models already placed before that date, which gives a bit of transitional time for providers to ensure compliance with those models, but they still have to ensure compliance by 2nd of August 2027. So that's why our rules and package are very important to facilitate that in line with the objectives of the AI Act.
Thank you very much, Jordanka, for this very comprehensive overview. So alongside the AI Act, now we also have a package, a GPAI package to support the implementation of all those provisions. Sabrina, could you clarify the content of this package and maybe also the interaction between the different documents that we have now, please?
Yeah, very happy to. And we also have a slide that helps explain this better. So as Jordanka already said, since August 2025, AI Act rules for providers of general purpose AI models apply. And some of those rules only apply to providers of the most advanced models, the rules to assess and mitigate systemic risks. It was important for the Commission to ensure that industry receives the support they need to actually comply with those rules. So we want to make it simple for them. First, the General Purpose AI Code of Practice was published. This is a voluntary tool for industry to demonstrate compliance. It was not developed by the AI office, but by 13 independent experts, together with input from over 1,000 stakeholders from industry, academia, civil society organizations, rights holders, where all their input was compiled into this one document. Later, that code of practice was then endorsed by the Commission and the member states. And so since 2nd of August this year, industry can rely on the code of practice to demonstrate compliance with the AI Act, so it supports them. This essentially gives guidance what has to be done to comply with the rules. Of course, it also needs to be clear who has to comply with those rules. And this is where the Commission guidelines come in. So after that, the Commission published guidelines to clarify the scope of the general purpose AI rules. For example, explaining when is an AI model a general purpose AI model, or what rules would apply when to downstream providers that would fine-tune these models to use them in their applications. A third part of the package is then the template to help providers summarize their data that they use to train their models. And this is also one of the key obligations, as Jordanka pointed out earlier. So also here we provide support to industry.
Thank you very much, Sabrina. So now it's time for us to delve into our first piece of the package. So that is the Code of Practice for GPAI model. As explained earlier, this document aims to support the obligation laid down, especially under Article 53 and 55 of the AI Act. So, Sabrina, drafting the Code of Practice was, of course, a unique and complex process for the AI office, but also for all stakeholders involved. Could you maybe outline the main features of this work?
Yes, of course. Let's look at three main features. So first, the pen holders. As I explained earlier, it was not written by the Commission, but by independent experts with input from many stakeholders. So we at the AI office were actually only facilitating this process. Second, also the dimensions of this process were truly unique. It involved over 1,400 participants from the different stakeholder groups that I explained earlier, also representatives from European member states and international observers. And so the independent experts developed the code through multiple drafting rounds, actually involving over 1,600 written submissions by all these stakeholders that were involved in 40 workshops. So you see, it is a truly unique process. And thirdly, let's look at the significance of this process, because it is actually the first time that legal rules were detailed out to describe what responsible and safe development and deployment of general purpose AI actually means. This is also why there was so much interest in this process. And now over 25 providers have voluntarily signed up to this code. So we see that the fruits of this work are very huge.
Thank you very much, Sabrina. So now we have this code of practice, and a preliminary point to clarify is its structure. So what are the main chapters of the code? How long are they? And do they constitute one or several documents? Can you clarify that, please?
Yes. So there's one code, but 3 chapters to the code. We also have a slide to explain this better. So on the left side, you see what Jolanta explained earlier, that for all general purpose AI models in the AI Act, there are rules on transparency and copyright. And so there's also 2 chapters in the code that address the transparency rules related to the documentation that providers have to provide, as well as on copyright. For the transparency chapter, the code offers a user-friendly model documentation form to make it really easy for industry to document the necessary information in one place. For copyright, the code offers practical solutions to put in place a policy complying with EU copyright law. Then let's look to the right side. So only for the few providers of the most advanced models, there's a chapter on safety and security. And this is actually the largest chapter in the code of practice. It basically puts forward relevant state-of-the-art practices on how to comply with the rules in the AI Act to assess and mitigate systemic risks.
Excellent. Thank you very much. So now we will discuss the different chapters, and we can start with the chapter on transparency. Jolanta, what is the scope of this chapter on transparency, please?
So indeed, the chapter on transparency aims to cover and provide a simple way for providers to demonstrate compliance with their obligations, what they have to document and provide towards the AI office in our future supervisory action, as well as national competent authorities, as well as downstream providers. So as said by Sabrina, it is a very much straightforward chapter with clear obligations to document the relevant information, that also providers can use a model documentation form to actually help them, which is just a voluntary tool, so they can also obviously use other means, but it provides a very easy and practical way through a simple documentation how they can actually fulfill all the information that they have to put in place in one place. For what they have to document and how it is prescribed in the AI Act in the Annexes 11 and also 12 towards the downstream providers. So it includes information like about the model development, architecture, parameters, but also more practical information about the training data processes, the tools available, and other energy efficiency, so all elements that are already provided clearly in the AI Act. It's important to know that in this chapter there is legally also the obligation for providers with systemic risks to document the model evaluation methodologies, the results, and all this is now implemented in the safety and security chapter. So that's very important to emphasize, and then providers can use and should follow this information where they can clearly document, and there are very easy ways for them to understand what they can provide to the AI office based on explicit request from us, or also when this is needed, when we could request it on behalf of national competent authorities for future checks of possible AI systems supervised under the AI Act that are built on those models. as well as to these downstream providers, so they can very easily and simply provide that information. So as said, then downstream providers could also request even additional information, but then they have to also demonstrate with the request how they can use that information when they need it, also for the understanding the capabilities, limitations. There are also already commitments from the providers to provide it timely and within reasonable timeline, within 14 days. And then there are also very important commitments in relation to keeping this information up to date, also ensuring it is also accurate, respects integrity, security, so that can really serve the purposes for both the providers to rely on it, but also for the future supervision on us. It's very important finally to emphasize that this information is subject to confidentiality obligations also on our side. So there will be specific safeguards, and also by requesting it, we'll also make sure that this is only when it's needed also for our future enforcement activities. And it should be also clear that in the end there is an encouragement also in the code itself that providers can also provide publicly, if they see it relevant, also information to the general public related to some of these elements that could be relevant to enhance transparency.
Thank you very much, Jordanka. Let us move on to the chapter on copyrights now. This chapter laid down 5 commitment measures for signatories at the intersection of Article 53(1)(c) of the AI Act and related EU copyright law. So, Jordanka, how can these measures help GPAI models to effectively comply with copyright?
Yes, indeed. The main obligation of the relevant provision in the AI Act is for providers already to take measures to have organizational policy at place to ensure that they comply with existing copyright legislation. So it's very important to emphasize these are not copyright rules. There is already the applicable copyright legislation that the objective here is just to facilitate the effective implementation. And what the code does in this area is to be very specific with practical solutions and elements what providers need to put in place for this policy, as well as the responsible people who should be following and overseeing its effective implementation. There are also very practical measures that providers commit to take, those who sign the code, and which will be also supervised by us as the AI office. So first, there is a commitment for all providers to ensure that exclude from their web crawlings piracy websites that are recognized, and they also do not circumvent technical measures that aim to prevent unauthorized access to the content, such as paywalls, for example. Secondly, there is an important commitment related to the opt-out from the text and data mining exception I mentioned before, because in order to ensure that right holders who have reserved their rights from the text and data mining exception and do not want their content to be used for further training, then providers would effectively respect these opt-out solutions. And here there are clear commitments also to respect RobotTXT, which is already recognized as a state-of-the-art standard, future IETF standards, but also state-of-the-art machine-readable protocols that will also be agreed upon and then are widely used also by right holders, and that providers will also respect effectively, and they will also provide transparency about the crawlers used. And then thirdly, there are also important commitments related to the output of those models, because sometimes they can also generate output that is copyright infringing, especially if it is used on copyright protected data. So here the objective is that they implement effective measures to prevent the models from generating such outputs that are copyright infringing from the training data. And then finally also they have to put in place a mechanism for complaints to enable also right holders to have access and possibilities if providers don't comply with these commitments, to ensure that they can be also effectively implemented and followed. So it's very important again to state that compliance with the code and the measures in the code does not mean that providers complied with union copyright legislation. It remains fully applicable. Right holders also have all the rights, remedies under national court and national legislation to exercise their rights. So this is more like an additional complementary measures that we as DI office can supervise, and providers commit to implement in a preventive manner.
Thank you very much, Jordanka. Very insightful. Let's move on now on the chapter dedicated to safety. It includes 10 commitments and around 30 measures within this commitment, plus 4 appendices. So it's a very detailed document aiming to support the implementation of Article 55(1) of the AI Act related to the obligation for GPAI models providers with systemic risks. Lauro, what are the key elements provided by this chapter, in particular as regard the implementation of these obligations?
Yeah, so the chapter on safety and security is essentially about assessing and mitigating systemic risks. So systemic risks are risks of large-scale harm from the most advanced models. The code gives a few examples here, and I'll list some of them, not all of them. So first, a model that is used or enables terrorists to build a biological weapon. This is, it's clearly large scale and specific to the capabilities of the model. This is something that companies are already worried about, and might become a more pressing problem in the future as the capabilities of models to help scientific and engineering projects to go along increase. Second example is a model that acts autonomously to escape human control, for example, by copying its weights onto a different server, and thereby escapes basically our ability to reliably direct or shut it down. Finally, a third example is a model that enables large-scale autonomous cyber attacks. So these are all examples of risks that are specific to and that emerge from the capabilities of the most advanced models as the technology progresses. In the code, signatories commit to taking concrete measures to manage these risks. So as Marion, as you mentioned, it's a fairly detailed document, and so I'm not going to list everything that that the code provides for, but I'm going to try and give an overview over the key parts. So first of all, signatories identify systemic risks. This means they take into account information about the model, but also contextual information to try and identify potential risks. Then they take those identified risks and analyze them. This means they use a variety of methods, most centrally model evaluations, to better understand the capabilities of the models involved and their behavior in order to assess risks. And then finally, signatories make a determination about whether the risks posed by a model are acceptable or not, and if not, they apply mitigations. A key element also of this entire process is the involvement of independent external evaluators. They're not involved for all models under all circumstances, but under specific circumstances, it is important to involve them, and the code provides for that. Additionally, signatories also put in place security measures. These mainly function to prevent model weights from being stolen by threat actors. And in addition to these measures, which are mainly about the actions that the signatory takes to prevent risks emerging from the model, signatories also report to the AI office about their management of these risks. So mainly what they do here is they write a so-called safety and security framework. This is a description of the signatory's overarching approach to managing systemic risks. A key element here is so-called risk tiers, which describe under which circumstances the risks from a model are acceptable and under which circumstances they aren't. And then if they aren't, what mitigations should be applied to keep risk to acceptable levels. So this safety and security framework is reported and sent to the AI office, as well as model reports, which are a summary of the risk management process and the results of that process for a specific model that then upon model release is also sent to the AI office. Finally, if there is a serious incident, for example, a cyber attack, signatories are required by the AI Act, and this is further detailed out in the code, to send reports of those serious incidents to the AI office.
Excellent. Thank you very much, Lauro. A last question to conclude this first part on the code of practice, a very important question on the legal force of the code. Sabrina, what is actually the legal force of the code? And also, can you tell us more on the process as well as the consequences of adherence to the code, please?
Thank you, Marion. So the Code of Practice is a simple and transparent way to demonstrate compliance with the AI Act. It is purely voluntary for providers to choose to sign up to the code. Let's differentiate what this means for signatories versus non-signatories. So signatories enjoy less administrative burden because the Commission has more trust, because we know that they would follow the Code of Practice to demonstrate compliance. So the AI Office's enforcement focuses on monitoring the signatories' adherence to the code on the basis of the Code of Practice. When fixing the amount of fines, the code can also be seen as a mitigating factor in assessing these or in fixing those fines. Still, it's important to note that the code does not provide a presumption of conformity. So it is still on all signatories to implement the code and to demonstrate compliance with the AI Act. Now, non-signatories cannot enjoy these benefits because they have not signed up to the code and they do not adhere to the code if they do not adhere to the code. So they are expected to demonstrate compliance via alternative means. And this means they also have to explain to us like what measures they put in place to demonstrate compliance. So they might also be subject to a larger amount of requests for information or access to model evaluations. So you see there are like strong differences between signatories and non-signatories. Now, at the end of this, we were very happy to see that already, as mentioned before, over 25 signatories have signed up to the code. So we look forward to collaborating with those actors.
Thank you very much, Sabrina, for this response. It's time now for us to take some questions from the Slido application, so Q&A. We have a first interesting question on the interaction between guidelines, code of practice, and the sanctions. So I read it. Could you explain the relevance of the guidelines and the code of practice to sanctions under Article 99 to 101 of the AI Act? Legal question, maybe, Jolanta?
Yes, a very important question. So indeed, the Code of Practice, as it is approved by the Commission and also the AI Board, it provides a valuable means for providers to demonstrate compliance. So those who sign then also benefit from this increased transparency, trust on our side, so we can take into account the signatures and also compliance for future in our future supervisory activities, including when we decide the concrete amount of fines. Now, the guidelines that we are going to discuss later on, this is the document that is adopted by the Commission. So while it is non-binding in nature, it provides important clarifications for all providers, how we as a supervisory authority understand the scope of the obligations, the remits, and also the implementation. So we are going to dive a bit deeper into very important legal questions like who is the provider when the system, when the model is placed on the market, or when a downstream provider modifies that model. So there are important scenarios. So when, for example, the open source exceptions can be relied upon by providers. So these are important elements for which we aim to provide clarifications for providers to better understand their responsibility. But of course, it is on them following these guidelines as said, both to properly analyze their concrete situation, assess if they have additional questions. Also, we have this collaborative approach to further engage with them, to help both in the and provide support in the compliance, as well as clarify any other issues. And then as said by Sabrina, just relying on the code doesn't mean they have presumption of compliance. In case of future checks, also on our side, they still have to demonstrate that they have effectively implemented the commitment. So we'll still exercise all our future supervisory functions. But as said, obviously we have much more transparency, and both us as future supervisor, but future clients and the society as well, by knowing already which provider has decided to sign to the code, and on the other hand, those who have not, how they should also demonstrate and prove that they have taken effective measures as well to fulfill the obligations, because they are fully applicable, and the fines and our supervisory powers apply regardless of whether you are signatory or not to the
Excellent, code. Excellent. Thank you very much, Jordanka. A general question: will you provide a list of Gen AI models?
I think the existing, currently under the AI Act, there is an obligation to actually publish a list on models that are posing systemic risks. After this, as I explained, taking into account the transitional rules, when they also become applicable, the rules to those models, if they have been placed on the market already before the 2nd of August, because for those models there is still this transitional period. So obviously for all new models there is also obligation, especially if a certain threshold for compute that Laura will explain later on when we dive deeper into the guidelines, they have to notify us as well and follow specific procedure for so for models with posing systemic risks that are classified as such, yes, we need and we are going to publish them. But for other models that are just general purpose AI models, they are widely available. There is no such prior reporting obligation towards us, and our supervisory powers are more ex post, just to see whether compliance with the measures we discussed before are at place, but not actually ex ante registering these models.
Okay, excellent. A question on the code process. Do the signatories of the code of practice, so for GPAI models, have a deadline to demonstrate compliance?
Well, the rules apply. Yeah. So in a sense, in order to be compliant with the law, they do need to adhere to the code from August, so from a few months ago. That said, there are timelines in the code for providing the required reporting, so safety frameworks, model reports. For example, model reports are only required when a model has to be placed on the market. So they have certain amounts of time for these reporting obligations that are specified in the code. And then additionally, we also take into account in our conversations with providers and in our enforcement that there is a certain amount of time that is required to implement all the necessary processes that are required to adhere to the code. And so we also understand that in some cases, it takes them some time, but there's no concrete deadline.
Excellent, thank you very much. A question on transparency, maybe Jordanka. If the AI output is reviewed by human, then is there still a requirement to inform the recipient that AI was initially used to generate the output?
I think that this is a very pertinent question, but maybe we'll talk about this in the end of our presentation, because actually it relates to generative AI systems, which are regulated under another section of the AI Act. So this is very important difference, because the rules for general purpose AI models, they apply upstream, and they cover in this specific chapter here, when we talk about transparency, this transparency more in terms of documentation, value chain information that downstream providers can obtain, or more on the input side, what data has been used for the model to actually be trained. So then further on, other users have better understanding, and also citizens or right holders affected can better understand the information. But regarding the obligation that is asked now, whether, for example, if a human reviews the output, it still needs to be labeled as an AI output. This relates to another obligation in the AI Act, which is in Article 50. It's not yet in place. We are going to announce also in the end and call everyone adjust our future processes to support compliance with this. Yeah, it is something more to come in the future that will clarify as of these next processes that we organize.
Thank you very much, Jordanka. It's true that a lot of questions are also dealing with our second part on guidelines. So I propose that we start our second part, and we can also respond some of the questions linked to the guidelines after our second part, if you all agree. So let's start our part on guidelines on the scope of obligation for providers of GPAI models. So GPAI models have an important place under the AI Act. We saw that. First, the Act draws an important distinction between GPAI with or without systemic risks. And second, the AI Act laid down this two-tier legal regime for GPAI models depending on their characterization. So in order to clarify those key elements, the guidelines were published on July 2025, and they focus on 4 key topics. We discussed that briefly earlier: the concept of GPAI models, the meaning of placing GPAI models on the market for providers, exemptions from certain obligation for providers of GPAI models released as open source, and finally, public enforcement scheme, including the role of the AI office. So to start with, it's important to understand when an AI model would be considered as a general purpose AI model. So maybe we can start with the definition under the AI Act, so Article 363 of the AI Act. So it means a model trained with a large amount of data, and I quote, that displays significant generality and is capable of competently performing a wide range of distinct tasks. So Lauro, could you explain us this core concept of wide range of tasks, please?
Thanks, yeah, happy to. So in the guidelines, we try to make a little bit more concrete what the meaning is of a wide range of distinct tasks, significant generality, these elements of the definition. A central example, to just give a little bit of context on what what it means to have a wide range of tasks is a language model. So language models are, they're capable of answering science questions, writing a shopping list, writing poems, making jokes. They can browse the web. They can write software, even to a surprisingly maybe not autonomous degree. And so that's one central example. We do also, in addition to language models, consider other models to qualify as general purpose AI. For example, models that generate images, video, or audio. Now, there are subtleties involved here, and for the details, I recommend to look at the guidelines. I'll summarize here something that we call an indicative criterion for what we consider to be a general purpose AI model. It's not enough to just be a language model or just be an image generating model, because of the requirement that you not only perform a wide range of tasks, you need to competently perform them. So there's an element of there needs to be a sufficient degree of capability involved of the model. The way we operationalize this in the guidelines is that we say that an indicative criterion for when a model is general purpose is that, first of all, it is one of the modalities, one of the types of models that I just mentioned, so language, image, video, audio, and that it is trained with more than 10 to the 23 floating point operations, FLOP. We use this criterion because the amount of compute that is used to train a model is a very effective heuristic proxy for how capable it is. And so it's important to mention, of course, that, or underline that this is an indicative criterion. It is possible for models that don't satisfy this criterion to be a general purpose AI model, and vice versa. For models that satisfy the criterion, there are exceptions where we would consider them to not be general purpose. And here I would again suggest to read the guidelines if anyone is more interested in the fine details here.
Excellent. Thank you very much. So only few GPAI models are considered to be a GPAI model with systemic risk. Additional rules will apply in that case. The AI Act set out several factors actually for classifying models with systemic risk, which the guidelines clarify further. So Lauro, could you explain this dimension?
Yeah. So the general idea or the underlying motivation is that models with systemic risk are the most advanced models. So and that's then why also more obligations apply, the ones I mentioned earlier that the safety and security chapter of the code outlines. The main way in practice that a model ends up being classified as having systemic risk is the famous compute threshold of 10 to the 25 floating point operations. Now, this is, again, like I mentioned earlier, because compute is a very effective heuristic for measuring capabilities. And so when a model is above this threshold, it is presumed to have so-called high-impact capabilities and thus have systemic risks. Again, here it's important to note that this is just a presumption. So that means that there are cases where a model exceeds the threshold where it might not be considered to have systemic risks. In such a case, the provider of that model can send and write to the Commission and argue and explain why the model should not be considered to have systemic risks, why despite exceeding the threshold, it is not actually one of the most advanced models. And in that case, we would look at the argument, and if the argument is sufficiently substantiated, the model would not be considered to have systemic risks despite exceeding the threshold. And if also vice versa, models that don't exceed the threshold can, in some cases, be designated by the Commission as having systemic risks.
Excellent, very enlightening. Thank you very much, Lauro. The AI Act also provides for an exception for certain models released as open source. We say that previously, except when the model is with systemic risk. Lauro, could you first explain the rationale behind that provision, that exemption, and then the condition, please?
Sounds good. So the idea here is that open source models are exempt from the provision to provide certain information to the AI office, downstream providers, and national competent authorities. The main reason for this is that, well, basically there are two reasons. One is that open source models are useful for research and thus for innovation. And so there's reason to want to make the placing on the market of open source models simpler. And the second reason is that as open source models are to some degree by design transparent, it makes sense for them to not have to comply with all of the transparency obligations since they already provide a heightened degree of transparency. Now, this exemption applies under certain conditions. The model must be released under a free and open source license. And my colleague Joranka here is the expert, so I'm going to hand over to her for explaining the details.
Yes, indeed. It's also a question of what is an open source. So we have a clear understanding when this exception can be relied upon. And then the Act imposes first the condition that about the licenses, that they should be free and open source. So they should, what that means in practice is that they should allow openly to all users to freely access, use, modify the model, as well as further distribute it without imposing additional restrictions. So this is very important in order to enable the free use of these models for further innovation that can be really beneficial for the wider ecosystem more broadly in Europe that we strongly support. And then secondly, as said, in order to consider these models by default transparent, they also have to comply with certain transparency obligations as well. So they also have to release the parameters, including the weights. They have to also provide transparency on the model architecture as well as the model usage that should include relevant information for all these downstream providers who want to rely on these models to effectively integrate and use them into concrete applications. So that's why in practice these mirror more or less the conditions that we have in these annexes with the model documentation form. But it doesn't exempt providers, for example, to still comply with copyright or with the documentation and the summary for the content used for the training, because the model training data is not fully transparent at this stage. And then also one important clarification as well for providers to rely on this exception, that they should not also monetize by providing the model based from this release. So it should be free as well for users. And then we provide also in the guidelines relevant examples when this could happen, when this monetization could happen. For example, if they provide, for example, they require monetization to get access to the model, or also if they provide additional services that are directly linked, inextricable also to the model for security, other reasons, or personal data processing when they also use it for commercial purposes. So all these conditions need to be at place for providers to be able to rely on the exception. Yes, as the other guidelines, we welcome everyone also to read them. But it's a very helpful way also to take into account the specific nature of open source and exempt them from certain obligations for transparency in particular, while enabling the still and addressing the other risks and compliance with the other obligation that should be in place.
Thank you very much, both of you. So many European businesses built on GPAI models, in particular through fine-tuning. So Lauro, if a company fine-tunes an existing model and then places this fine-tuned model on the European market, does it have to comply with the GPAI obligations?
Yeah, so if a company takes a model from a different provider and then fine-tunes it, we consider that model, or the guidelines consider that model to be in scope if the fine-tuning, if the modification that is being done on the model significantly changes the model's capabilities or significantly increases risks. So concretely, what does this mean? Well, to actually concretize it in the guidelines, we provide, again, a heuristic based on compute. So we consider that when a model is fine-tuned with more than 1/3 of the total amount of compute that was originally used to train the model, then it is considered a new model, and thus the entity that is fine-tuning the model is considered the provider of that new model. It's important to clarify and emphasize that this applies only when a provider fine-tunes a model that was originally trained by a different provider. If an entity fine-tunes a model that they themselves trained originally from scratch, then even if they surpass this 1/3 additional fine-tuning compute threshold, the model is not considered to be a different model. It's always considered to be the same model throughout the entire life cycle of the model. So this is something that only applies when a different entity fine-tunes a model.
Okay, excellent. Thank you very much. Maybe a last question on the AI Office role in supervising and enforcing obligation for providers of GPAI models. What are the main elements that the guidelines aim to clarify in that regard, including on the next step for companies? Lauro?
Yeah, so maybe the main element to emphasize here is that currently, while the obligations are already in force, they apply from August, so from a few months ago, so the AI Office's enforcement powers only apply from August 2026. This means that in this first year, we are not going to start any enforcement actions. We're not going to, for example, impose any fines. Instead, we're going to take a staged and collaborative approach to enforcement, where we work together with providers to make sure that they're compliant. In particular, the providers, of course, already need to comply with the law. So for providers, this means they put in place a copyright policy, they provide the necessary documentation and transparency. Mm-hmm. If the model poses systemic risks, they notify the AI Office when they are training a model and they know they will reach the compute threshold. And then when they notify us, and of course they send us their frameworks, their model reports, as assuming they're signatories to the code. And then we have a conversation with them about whether those frameworks or those model reports achieve the goals and the standards that are set out in the code.
Thank you very much. So we will start now our Q&A session for this second part on the guidelines. A first question on the concept of most advanced model. You mentioned this concept, Lauro. Could you clarify, when does a model count as most advanced?
So this is a bit of a tricky question. Beyond the compute threshold, in practice, it's the compute threshold, 10 to the 25 flop. If you're beyond that, you are presumed to you're presumed to be one of the most advanced models. Now, of course, things in AI change fast, and what was one of the most advanced models a year ago might not be today, and what today is one of the most advanced models might not be one of the most advanced models a year from now. So there is no precise specification that we can give for what counts as the most advanced models, because it changes all the time. And so in practice, the compute threshold is still the main thing to rely upon. But then, of course, we do expect providers to come to us and say, well, my model is above the compute threshold, but it's not one of the most advanced models anymore, because in the meantime, the market has evolved, the technology has progressed. And then they will present arguments to us, saying, and just explaining why this is the case, and we'll look at them on a case-by-case basis, and then we expect that some models will surpass the compute threshold, but not count as one of the most advanced.
Okay, thank you very much. Oui, Sabrina?
And because of what Lauro just pointed out, that these developments can be quite fast in general purpose AI, that's also why the AI Office is constantly monitoring these developments, right? So this flop threshold, it was foreseen by the co-legislators that it can be adapted to the technological advancement. So there's a constant feedback loop between how the technology evolves and ensuring that the flop threshold actually, is indicative of these advancements.
If I can also just
Yes, Jadonka,
complement
please, feel
that
free.
indeed the flop threshold is a very important indicative criteria for the presumption, but they are also for the AI office powers also to designate other models that might display such systemic risks based on other criteria that are also explicitly listed in the AI Act. Which can also relate to the capabilities of the models, specificities that really make these models, even if they have not been trained with so high compute thresholds, still displaying and posing these systemic risks, including, for example, taking into account the number of users, another criteria that we as the AI office for the future can also take into account to decide and have this really more practical approach also to see in addition to this flop threshold, where there exceptionally could be there other models that could pose such high systemic risks based on that methodology.
Okay, thank you very much. We have another question, conceptual question, so to say. In the guidelines, there is a notion of downstream modifier and providers. So what are the actual requirements for downstream providers which are not modifiers?
Well, you only become a provider if, like I described earlier, the change that you make is either significantly changes capabilities or significantly changes risk. So in practice, this is if you're above the 1/3 compute threshold of using for fine-tuning 1/3 of the amount of compute that would use to train the original model, then you become a downstream provider.
And maybe an important point to keep in mind for the downstream providers is that in addition to the general purpose AI rules in the AI Act, we also have other rules that apply for the systems. And then we follow that risk-based approach with proportionate rules and requirements for certain applications that could be high risk if they are explicitly listed in one of the annexes we have, or they could be even prohibited practices. So downstream providers that might rely or use these general purpose models for concrete AI application also will have their still responsibilities under the other rules under the AI Act that are important to keep in mind.
Okay, thank you. We have some question mentioning ChatGPT 5. So here a question on that. Does the AI Office plan to evaluate soon models that were released after August the 2nd, for example, ChatGPT 5? What will be the Office's approach until August 2, 2026?
Yeah, so indeed, we're keeping a list and looking at all of the models that are released after August 2025, and this includes like various activities where we look at the models, we look at public benchmark results. We will, in the course of this year, do more significant investigations also into the capabilities and propensities of those models, and especially regarding to whether they pose systemic risks, and of course then, insofar as those models are provided by a signatory of the Code of Practice, we will also have a lot of information from the safety frameworks, from the model reports that are provided in the course of adhering to the Code of Practice.
Thank you very much. Some questions on the documentation. How will the AI Office assess the documentation sent by providers to decide compliance? Which assessment criteria will be used?
Well, the model documentation form, which is a simple way for providers who are signatories to the code, is very clear in the different elements, actually, what they have to document, even with concrete examples, really to help facilitate the easy documentation by them. If model providers rely on this model documentation form, and as we, as the AI Office, have assessed the Code of Practice this as adequate means for us, that would be a starting point. We would request that information on just when we need specific elements, because it might not be always the case that we need the full set of documentation. And then it's important to state that we as the office, for the actual supervision, we also have broader powers once they become really effective to get access to other documentation, information that the provider has, that we can actually explain and justify why it's necessary for us. So the model documentation form is the important basis, but then of course in future requests that we can make, we can also go beyond that when other information is maintained by the providers.
Thank you very much. We have also interesting questions on the role of deployers of GPAI models. So as a deployer, how to evaluate the information that the providers gives to the deployer, such as documentation on transparency, data, copyright, and so on. Is there a criteria to assess it?
Yes, indeed, the model documentation form and already the AI Act itself prescribes certain information that should be shared always with downstream providers. So this really aims to have an easy way for all providers who want to use these models to build specific applications, to have transparency, better understanding for what are the capabilities, limitations. But then it's true that some, for example, of the applications that are built could be subject to additional requirements, like, for example, the requirements for high risk, which are broader than just any AI application. So in that case, the downstream provider could also request additional information from the general purpose AI model provider when this is needed for them to actually ensure compliance with other obligations in the Act, such as the high-risk requirements. And then there is this collaboration and commitment from the general purpose AI model provider in a timely manner also to provide that information, because that is very important for this value chain, transparency and effective implementation for the whole AI Act.
Thank you very much, Jordanka. A question on the interaction between high-risk AI system and GPAI models. Does integrating a GPAI model into a medical device automatically classify it as high-risk AI system under the AI Act?
Maybe I take that one as well.
Yes, yes.
No, clearly it doesn't classify them, because we have very different rules for classification of general purpose AI models, and when they pose systemic risks with concrete obligations that we were just discussing today with all this supporting GPAI package we have put in place, compared to the obligations for high-risk AI systems, which are only considered as high risk and subject to these additional requirements. If, for example, for medical device and other regulated products, they fulfill two conditions. So it's really the AI system should be the safety component of that product, and it should be subject to third-party conformity assessment by notified bodies under the existing product safety legislation, in this case medical device, or the system should be itself a product, regulated product, like for example a software medical device. So only in these cases then the actual downstream provider who integrates the model into concrete AI application for specific purpose, like the medical device, but that could be other cases, whether embedded in products, or then for other high-risk systems in certain areas that are exhaustively listed also in other sections of the AI Act, which we'll discuss in other seminars when we move closer to the implementation of these rules. But just to really emphasize, the obligations are very specific, and it clearly doesn't flow just by being a GPAI model provider that you would necessarily be a high-risk AI system, for sure.
Okay, thank you very much. Last question, maybe a tricky question, I don't know, but it's about the Annex 4 on technical documentation. It seems difficult here for some stakeholders to understand everything. Will the AI office provide some guidelines on this Annex 4 on technical documentation?
Yes, so the Annex 4 is something related to the requirements for high-risk AI systems. So again, it is different. It's about rules and also consultations we've already finished. And then in the future, we are now preparing guidelines first for the high-risk classifications, but also to support compliance with the obligations, requirements, where we are going to provide additional guidance. But importantly, we also have European harmonized standards that could be relied upon and that are now in process of being developed, also on which providers could in the future rely upon and have presumption of compliance. But as said, these are still rules that are coming into force later, and there are additional processes to further support their implementation.
Thank you very much. Thank you very much for all those very interesting questions. We need to move on. We still have a third part to deal with about the template for the public summary of training content for GPAI models. Maybe a few words of content to begin with. Article 53(1)(d) of the AI Act requires all providers of GPAI model to draw up and make publicly available, I quote, a sufficiently detailed public summary of the content used for the training of the model. So that's the so-called summary. In order to guide organizations in drawing up this summary, the AI Act lays down that the AI Office shall provide a template, so the so-called template. As recalled earlier, the AI Office actually published this template this summer on 24 July 2025. So to begin with, Jordanka, could you tell us how the AI Office developed the template and what is its core objective and maybe its structure?
Yes, happy to do so. Indeed, this is a very important third deliverable that we have developed as the AI Office and the Commission to support the implementation of this obligation for the sufficiently detailed summary. So it is not addressed in the code. So this is a complementary template that all providers, whether they are signatories to the code or not signatories, have to fulfill, and it aims to provide this single, uniform and simple way for providers to actually document the information and explain what should be considered as sufficiently summary when they provide transparency about the training data. And the core objective of this is to enable third parties with a legitimate interest under union legislation, like right holders, but also others that can rely on whose data could have been used or then could gain other insights to further support, for example, more competitiveness of fundamental rights protections based on the transparent disclosures of what type of data, training data has been used. And then there has been also this very careful balance, thinking about transparency, that we also need to ensure and take due account, for example, of the trade secrets from the providers in order to make sure that there is this fair balance and we achieve the objective of transparency. So based on multiple consultations we have organized already over the summer to get input, but then also later on with proposing a first proposal that was also discussed in the context of the Code of Practice with all participants, there are more than 1,000, and obtaining further input, we've tried to really carefully tailor the exact content of what information providers should disclose in order to effectively achieve objectives of the transparency, but also take due account of the trade secrets and ensure this tailored disclosure and granularity of the information that we have tried to follow with 3 distinct sections in the template. So first, providing general information for the model provider, also the model itself, the different modalities, type of content used, then very specific section on the list of specific data sources that were used by the providers, and then finally certain relevant data processing aspects that could support the effective exercise of the rights and increased transparency.
Excellent, thank you very much, Jordanka. Regarding the scope of the second part, so that is a list of data sources, stakeholders are required to publicly disclose only training data, not the other data. So could you, Jordanka, detail the contour of this obligation and what are more specifically the types of sources that are required to be disclosed here, please?
Yes, that's an important question because the legal obligation is only about the training data, but at the same time it has to cover training data that can be used in different stages of the model development process, both from the pre-training but also further modifications, fine-tuning, as long as actually this data has been used for the development of the model itself. So operational data is not part of it as long as the model doesn't learn directly from it in order to gain these new insights and capabilities. So that's an important first clarification on the scope. Regarding the disclosures about the sources, the AI Act is also very clear that the provider should comprehensively disclose all types of data sources. So clearly very relevant in this context are copyright protected content, but also are other data that providers have used. And then we have tried to create specific categories where they can, in an easy way, depending on the sources from which they have obtained that data, can disclose and describe the data. So first, for example, we have the category of publicly accessible data sets, which we see on many online platforms that can be effectively used. They are also shared often through open source and used by many providers to develop training models. So then they have to be listed, especially the large ones that have important impact for the training, and then they have to be fully and comprehensively documented and also provided with links for these large data sets, also with additional information and other specificities, so that can comprehensively give information for both the affected parties but also other providers who want to use the system further down. Then we have the category of private non-public data sets. So here we cover 2 types of categories, either data that has been obtained through licensing agreement with right holders, where obviously the risks are less and the need for transparency is less pronounced because right holders have been remunerated for this. So here we require less information. There could be also other categories of private data sets that are provided from other third parties that could also have certain trade secret considerations. In this case, they still have to be comprehensively documented. If they are also publicly known, they also have to be disclosed. a very important category, and actually one of the biggest detailed elements in the template is the data which is scraped from the internet directly by the providers or on their behalf, because we know that often a lot of these crawlers have been used, and a lot of the available online content has actually fed most of the general purpose AI model developed up to date. And here providers have to disclose important information about the name of the crawlers, the period, but also comprehensive descriptions already of the full scraped data, as well as to increase the transparency and make also the template more effective in the, achieving its objective to help right holders. There is also the requirement that they should list also 10% of the top domain names that they have scraped, or also for SMEs, these are top 5% or 1,000 domain names. And then there are also some other sources like user data, for example, when providers directly obtain this data from interaction of their services directly with users, or even the model itself, or synthetic data, for example, when providers directly generate the model on the output of models where there is also less information disclosed, but still it could be relevant. Also, for example, like the name of the GPAI model that is already available.
Thank you very much for this very comprehensive overview, Jordanka. Maybe now the opposite scenario. The complete list of data may not be accessible. So in such instance, what should the provider do to satisfy the transparency obligation?
Yes, that's an important practical consideration, because we know actually that even before the AI Act become applicable, a lot of these models are already trained, many of them are already placed on the market. So in those cases, when the providers with their best effort still cannot retrieve and they don't have the available information, they should clearly disclose that and justify that, but in general that doesn't absolve them from the obligation to fulfill the template still with the available data, and be very transparent about any gaps, and that clearly applies only to take into account for ex post training and models placed on the market. But for the future, the objective is really to stimulate and ensure effective transparency for the future implementation.
Excellent. Thank you very much. A last question before our Q&A on the template. As regards updates and changes to existing GPAI models, Jordanka, how does the template address this question, and what are the expectations for providers regarding timely updates of the summary?
Yes, that is also a very important point, where we could differentiate again two scenarios. So first, we could have a downstream provider who takes already an existing model, and in case that downstream provider, under the conditions that were explained already before very well by Lauro, under what cases they could, if they train above certain threshold with FLOP, further modify the models, when they could become responsible to comply with the Act obligation. In those cases, when they have to produce a summary, their documentation and transparency should be very limited only to the modification they have made. And then there should be also transparency about what model they have already used, so we could clearly make the link with other available summaries. In case we have the same model provider who just further trains the model, fine-tunes, then the obligation for updates still applies. And they have to also, in case there are for the future changes in the content that is disclosed in the template, they can either update the template at every 6 months interval, or as soon as there is this material change in the content itself. So it is ensured that it is timely, really kept up to date, and made available also publicly for the public, and also for us to see.
Okay, thank you very much. We start now our Q&A on that last part. We have questions on training data. First technical question, please, could you confirm that RAG, so retrieval augmented generation, is not training?
Yes.
You can confirm that.
Yes, this is also explained in the explanatory notice that is accompanying the template. It indeed draws this distinction between what is covered within the training process as opposed to other operational data used, including the retrieval augmented generation process. So as long as the model itself doesn't learn from that data, but it more just acts as a search engine or just to retrieve the information and disclose it, it's not covered. But if there are elements where, of course, the template also provides for additional information, so it even allows more information if anyone wants to disclose. It is possible, but it's not legally obliged to do so.
Okay, excellent. Again, a question on the role of deployers. It's important. Do deployers of general purpose AI models need to request providers to fill in the form for training data and check compliance of the provider here?
No, because the obligation is in the Act itself, so it's already directly applicable. We have produced the template, so for all models that are placed on the market after 2nd of August, providers do have these obligations that they should fulfill. And obviously they are subject, for once our future enforcement becomes into force, we can also take actions to ensure that, but the obligation is already directly applicable, so it's not that anyone has to ask them to do that.
Okay, excellent. We have a question, a more general question, maybe to open, because it's the end of our session in few minutes. How does the regulation, so the AI Act and this package, going to be adapted to current technological tendencies? In particular here, now large language models and agents may categorize as GPAI models. However, small language model may not categorize as GPAI, performing like LLM. So what are your views here?
Well, I mean, I think one central example of things that could be changed in the future, like a way we could change our approach, is updating the compute threshold. Sabrina already mentioned this.
Maybe something else to point out is that, of course, the code of practice was written from 2024 to 2025, right? But it's also a possibility to update the code in the future, so that would allow us to, address adapt the content of the code to how the technology evolves. So this is another mechanism where we can ensure that the general purpose AI rules stay future-proof.
Okay, excellent. A general question on the understanding of the AI Act in the economic ecosystem, more for small businesses. This participant says it's difficult to explain what the AI Act means for simple business owners, so not AI developers, but users. Could you respond? Could you help this participant?
So maybe coming back to how we opened the session, right? So we know that there are now these rules for general purpose AI model providers that are like upstream in the value chain. So it's like a few general purpose AI models are being integrated in like many downstream applications. So first there are the models, then they're integrated in the different systems and applications that are then governed, as Jordanka pointed out, sometimes also under the AI Act. And then it can also reach the user. And essentially the AI Act applies from the models to the systems to ensure that the systems and applications that any user can access, that those are safe and trustworthy. And this is how the general purpose AI and the entire AI Act contribute to uptake of AI in Europe.
Thank you, excellent. You want to add?
Yeah,
or
maybe
something,
one
Laura?
useful thing to mention is that there will be soon something we call the Single Information Platform for the AI Act, and this is going to be a resource, I think, for especially small business owners, where they can get information on the AI Act, and there will also be, as I understand, the possibility to ask questions and then get responses.
Excellent. Thank you very much. Last point before we conclude, there is another process going on. Jordánka, can you share some elements here, please?
Yes,
we have a slide, I think, about
indeed,
that.
we have a slide, and this relates to another obligation in the Act that more applies to the systems, and especially the generative AI systems that produce text, video, audio, or other generated content, even in some cases deepfake. And for those, we have specific obligations in the Act in Article 50 that will apply as of August next year, and they are very pragmatic also to enhance transparency, for example, both for chatbots, for example, other interactive systems, to show when they are interacting with people it is AI. So we really ensure that trust and transparency and not deceive people, as well as for people, for example, to know when deep fakes are labeled, or more broadly for providers to embed technical marks to enable actually the effective detection when AI generated content has been created. Or there are also some obligations related to emotion recognition biometric system, when they also need to be transparent when we as users are exposed to them. So for these, we have now launched a new process, first for stakeholder consultation, inviting all stakeholders to provide input for us, for our future guidelines in the Commission, to clarify these obligations, their scope and help both providers, deployers understand their responsibilities and implement them. And then secondly, we'll also have another code of practice that will be again a voluntary tool, especially for the providers of generative AI systems, to ensure this transparency of the AI-generated outputs, and then for deployers to label visibly deepfakes or certain other text in certain cases. So for that code of practice, we are also now opening the process for all stakeholders to participate, as we had for the previous one, to help us design a good, effective code with the involvement of all stakeholders. And also we'll have again independent experts, chairs. So we also invite all academics and other independent experts to apply for this process that we aim to kick off as next steps in October, and then organize in the next 10 months the process for the drafting of the code. And we look forward to again come also here to this webinar, hopefully to further update everyone on this process as well. So please apply, and we look forward to collaborate also with you.
Thank you very much, Jordánka. We have now reached the end of this webinar. So I want to thank you all for this excellent discussion. It's very crucial to have this dialogue with the AI Office. So thank you very much. I also thank you, participants, for attending this seminar online. And we need your feedback. Yeah, there is a survey that you can fill in. You have a QR code appearing on your screen to fill in this survey, so we can improve this AI Pact webinars. And stay tuned, because we have a next session in November 2025, and we will discuss innovation and sandboxes under the AI Act. Thank you very much.